Welcome, Eva. We appreciate your time today, and I have a whole big page to take notes because I'm in that age group where I need this information.
Okay,
So
well,
thank you for coming.
no, I'm happy to be here, happy to sub in for the man with the plan, the man on the sign, law practice of Dennison Keller. And if I'm looking to the side, it's because I've got a 2-screen setup and I want to make sure that I don't miss that important information for you. So thank you for hosting. Thank you for having us. I'm really excited to be here. If you want a brief intro, I often tell clients that I'm a recovering trial lawyer. So this is actually a second career for me. And I feel really honored to work with the law practice of Dennison Keller because we operate on a life care planning model. And I'll talk a little bit about what that is, but you can see the motto of the firm here on our first slide. And who respects the elderly is as if he respects the Lord. And that really speaks to me. I grew up with my grandfather who suffered from Alzheimer's disease, and we were exceptionally lucky. We kept him at home. You know, I watched my mother as his primary caregiver and a wonderful, wonderful group of in-home caregivers that we built relationship with over the years. Really give him an exceptional quality of life, although through the course of his disease, he left us piece by piece. But I always had an interest in elder law. I just knew that I wanted to talk to juries, right? And fight in courtrooms first. But when the opportunity came to join the law practice of Dennison Keller, I saw a way of helping families that went through the same thing I went through growing up. And to be 100% clear, right? I was a teenager, right? This was all my mom. But if we can provide your families with any better course through what can sometimes be very tough diagnoses, that is our role, right? And so I'm really, really pleased to be here. I'm very honored. And shall we get started? So all right. So I will say when I was joining the firm, right? What do? Right? We do wills, we do trusts, we do estate planning, we do guardianships, we do probate cases after clients have passed, and we do Medicaid planning for families, right? But please, I know everybody's muted. If you want to throw it in the chat. What are the things that all of these have in common? Anybody want to take a stab at it?
Also, you're welcome to unmute yourself if you rather speak than type out your answer.
Oh yes, I actually prefer that you join that we join the conversation together. All right, I've got one in the chat. I've got there for old people. Maureen Gartner, thank you so much for that. Yes, they are all for our elders. Any other suggestions of what things have in common?
They're also for protection.
They're also for protection. What are we protecting?
The people, the persons.
The persons. But what are these particular tools protecting that help the persons keep going?
Their money.
Their money. That's right. And so, you know, one of the things that I'm looking at and that Dennison is looking at is, have we really done our job if all we're focused on is protecting money, but we're not really working on quality of life, right? Because what is in some ways a path to having good quality of life, right? Having good care, having stability, having safety, right? But not going broke doing it. So there is an intersection between protecting assets, protecting money, and protecting our elders, but there's a missing piece here, okay? And so we often talk about the elder continuum, right? And if you look at this, it's all pretty self-explanatory, but you really never think of it in conjunction. You have your health, right? As your functions slowly decrease, right? You might need different types of living situations. You might need a living situation where, like in my family, we had healthcare in the home. You might need more intensive assistance, right? So you're moving down the path towards an assisted living facility, or even you might need nursing home care, right? And as you go through this continuum, the cost of those supports increase over time. So the cost of maintaining your quality of life slowly starts to rise, right? Then we look at, okay, well, how do we pay for it, right? Because part of our role is to help families look for varying benefits that can be used to support that quality of life. And that goes everything from perhaps VA benefits for veterans spouses, all the way up to Medicaid. And so we often have a situation where, like Evel Knievel, right? You're doing great, no limitations, living at home, independent.
Going over to Tom Bank
Sorry, thought I would, and feel free to bob in at any time. We have a situation where you are taking the jump, right? And you crash all the way at the end, right? And what do we call that? That is what we call a good crossing of the elder continuum, because what hasn't happened is the risk of not having planned for that middle part, right? As elder lawyers, you're often thinking, what have we done to prepare between retirement and end of life or estate planning? We do life care planning. What we're doing is bridging that gap, planning for the time in between. Oh, had a bit of a spot. So that I've outpaced my slides. You don't crash somewhere in the middle without being prepared. What we're doing as life care planners is protecting you from the sharks that may lie under the bridge. So we prepare elders by holistically caring for their journey through their care needs as they increase over time, but also by protecting their assets and making sure they don't outlive their resources. We often have clients come to us with these kinds of questions, right? How do I choose the right facility for a loved one? Am I eligible for veterans benefits? What if we have to move a family member out of a home care circumstance into long-term care? Is there a continuing care community that we can purchase into that will care for us as we move through the continuum? And those aren't really traditional lawyer questions, right? We have a team, and you'll see Dennison and I, as he likes to say, the boring suits on the side. We have a team that supports us, and they are our elder care coordinators, Myrnie and Debbie on top. They are Leanne, our Medicaid goddess. Her formal title is coordinator, but I like to call her a goddess. And we have other support staff members that deal with VA benefits, for example, and all of the wonderful people on the side that aren't the boring lawyers. They help the families address that puzzle that we saw in the last slide. So what do we do as life care planners, right? We take a multiple step approach. We meet with the clients, we meet with the clients' families, and then we send our elder care coordinators out to say, okay, what are the needs? We get a baseline of where the family is in terms of okay, have we just received a tough diagnosis, a chronic diagnosis that we know is going to slowly sap our ability to care for ourselves? We look at the finances and we say, okay, what sources of pay do we have to pay for that care? We make a plan, right? Not only to deal with after our client has passed, but what might happen during the challenges of the rest of this spiral, right? And we continue with the family, always touching them, right? To make sure that over time, when they are in need of appropriate additional supports, we make the application for VA benefits. We make the application for Medicaid in the assisted living facility. And so by continuously helping our clients through that care maze, but also making sure they have the documents in place to negotiate that. So as you can see, if you are well prepared, what we hope is that you will cross multiple numbers of trucks, just like Evel Knievel. Now, how do we cross the elder continuum? This is what you are here for. And so what you usually see recommended is having these 2 must-have documents, or as we say, preferably 3. And those documents are your healthcare power of attorney, your living will, and your financial power of attorney. So some of you may be looking at me and saying, well, Eva, we have these in place. But if you do not have these in place, right, this is the time, right? We always say the clients that make the steps that are needed before there is an emergency are always much better off than the clients that suddenly hit some sort of care crash and don't have these kinds of things in place. So let's start with the healthcare power of attorney. It's a document that says who is making your healthcare decisions, right? If you are unable, right? And so this isn't always a life or death decision. It comes into effect if you are only temporarily unconscious. And so what you are doing is you are naming an agent, right? We see plenty of healthcare powers of attorney. It's a form that you can easily complete, and clients often do themselves, right? But when they come into our office, what they often have are the spouses named, right? Who's your first logical support, your partner, the person that you love and care for and knows your most intimate wishes about how you wish to be treated. Well, what if that partner has then passed away? Do we have one child? Do we have multiple children? And so what we often recommend to clients is thinking about, okay, multiple backups are important to have in that document, and to make sure, right, that document is within your medical file, right? Where does that go? That goes to your primary care physician. That goes to the hospital that you are regularly being treated at if you have a chronic issue, or if you have an acute issue that you know you're going in for. Make it easy on them. I hate the idea of just saying, okay, if you give it to your primary care physician, it's going to be in your electronic medical file, but it's always better to over-inform rather than to under-inform. So have your healthcare power of attorney. Next is the living will, right? Now, the living will takes the point of view that you don't want to be kept alive by artificial means if you are in a terminal or a permanently unconscious state, right? And the important thing to know about a living will is that it actually trumps the healthcare power of attorney, right? It is the patient's own direction to the doctors about, okay, I am taking this opportunity now to say, I want to refuse treatment and receive only comfort care in this specific way. The other important thing is to make sure that, frankly, right, if you want to execute this document, that you do so, right? Just telling your kids like, hey, right, if this happens, I don't want these interventions to happen for my illness and for my course of the end of my life, it's not, it may be good enough, right? If your kids are your agents, and your kids are on your healthcare power of attorney, right? And if the doctors can reach them, right? But if you have the living will in place, what you're saying is, doc, don't take these steps. Please let me go naturally. So next we have the financial power of attorney, right? And so we will often have clients that bring in what are called springing financial powers of attorney, right? And those, they can have their place. I'm not going to say that they can't, right? But ultimately, when you're in a crisis, right, how difficult is it to get to a doctor sometimes that says, you know, you've lost capacity, right? So we write our financial powers of attorney to be live and hot when you sign them, right? This is a document that takes effect during your lifetime. And in this situation, right, what you're doing is you are naming an agent or agents to step into your shoes and to handle your financial life, right? That's scary for some people. You're giving away the keys to your castle. And so typically we're having in-depth conversations with clients about who do you trust to be this person for you? And what, if any, limitations might we need to put in for that person or for their backups so that they can step in seamlessly, right? If you have an emergency, but that you feel secure with the powers that you are giving them. It's always a balance between powers that are nice to have and that are useful when you are crossing the continuum, and concerns, maybe valid concerns, about limiting those powers. What do we have the ability to do if you have this power of attorney in place, right? Your agent has the ability to bank for you, to write checks for you, to sell real estate, to buy and sell stocks, to borrow money for you. And those are all probably things that you would expect that someone would need to do if they needed to step into your shoes to pay your bills, right? This is an example of something that we don't recommend. If you see a financial power of attorney that is like this, right? That is just, oh, okay, to do and perform all and every act whatsoever with regard to the management of this particular production company, right? That's not going to be good enough. What you want to do is you want to give specific powers. Now, Ohio has this wonderful statutory power of attorney. It's literally in Ohio law, and it is a great tool that families can use. But I want you to look at it carefully. Look at the page 2. You see all these great powers. Okay, you're going to be able to make a gift. We're going to be able to change beneficiary forms. We're going to be able to create a trust, things that you might want your, let's say, your children to be able to do for you. What does the first sentence of Ohio's statutory form say? Unless expressly authorized and initialed by me in the special instructions, this power of attorney doesn't grant these authorities to my agent to do any of the following, right? So unless you read this very carefully, and then you go through and you select these specific powers, you might think, oh, Eva, I filled out the statutory power of attorney form, but have you filled it out correctly, giving your family the powers that they need to help you cross the elder care continuum? Things to look for in your existing documents. We want you to have given your loved one, your agent, the person that you trust to take those keys to your castle, certain powers. Does it have the power to gift? I'm going to do a brief sojourn into Medicaid for y'all here as part of this presentation. And one of the things that we use as a tool for Medicaid planning is to get assets out of your name so that you can qualify for Medicaid. Does your financial power of attorney have that very important power? Does your financial power of attorney have the power to handle retirement accounts? You know, I'm not going to say that these documents are always perfectly honored, right? We will inevitably run into a certain financial institution or a pension fund that's like, oh, well, I'm sorry, does it say the Ohio Public Employees Retirement System in it? No, we're not going to accept that, right? But these documents certainly be the, hey, I'm the child, can I access mom's retirement account online? That's not going to work. The power to create a trust, we've talked about that, and we'll talk about that a little bit more later for you. And the power to self-deal, right? Will your child, will your loved one be able to include themselves along with their siblings in any of the wishes that you might have had that now they're trying to carry out? The last one's kind of weird, but it's something come up with just here in the past year or so, the power to appoint an authorized agent for Medicaid. Now, the Ohio Department of Job and Family Services will allow your agent, right, to do the Medicaid application for you. Great. What if your child is an exceptionally busy professional and they want to hire, for example, the law practice of Dennison Keller to help them do that with Leanne, our Medicaid goddess, right? Without that specific power and your power of attorney, you're going to run into problems in some of the counties in Ohio as to whether or not your child, your agent, and I'm making some assumptions here, right? That the logical person that you might choose to hand over the keys to your castle would be your child. But Ohio is going to say, oh, I'm sorry, right? There's no power to appoint the authorized representative that can help you be part of that interview, that can help you get the verifications that are needed to make that application. So we strongly recommend that you take a look at your existing documents if you have them, right? And that you update them. For example, all of our life care planning clients, we actually called them back in and added that power to appoint the authorized representative into their documents. Even if like we had just literally done one without that power 2 months ago. Always good to have that refreshed and recent and take care of those additional powers that are important for you and your agent to have to handle your affairs when you are not able to do so. So, well, Ava, you might ask, what happens if we don't do this planning? Well, you end up at our gorgeous Hamilton County Courthouse, and that is the process of guardianship. In that process, you are answering to a court. The court appoints a guardian of your person to make your personal decisions, a guardian of your estate to make your financial decisions. And that is a pretty onerous process. You are going to be going back and forth and literally getting permission for every dime that is getting spent, and that rightfully so, right? You're giving someone authority over that person's entire financial life, but it's also a public process, right? And it's a process that requires ongoing maintenance and ongoing filings of report with the probate court to make sure that the ward is being taken care of appropriately and under the law. So when we say get these documents in place to allow your loved ones to make these decisions for you, we're saying that because the alternative is a court-appointed guardian. So that is the 3 must-have documents if you were, right? Any questions on that before we do a brief sojourn into the world of Medicaid? And of course, I think we can have time for question and answer at the end if that is more preferential to everybody, Julia.
It's whatever you want. I can unmute everybody.
Y'all, do you have any questions? I've got something in the chat. Hold on just one second. All right, is this the same as a durable power of attorney? Yes, yes. Okay, so the statutory power of attorney is in fact durable, and all that means is that it survives any incompetency, however brief, of the principal, right, of the person that is making the power of attorney and designating that agent. So I hope that answered that question. Any other questions before we go back to the world of Medicaid? All right, y'all. I will come right back. So bear with me here for a second. All right. So keep your eye on the Medicaid ball. Medicaid is important because it is what we think of as the three-headed monster in our business. Now, you know, it is an important source of support for families to pay for varying forms of care needs. However, in order to access it, right, there are some rightful hoops that you have to jump through as a family. And so I'm going to talk about the programs, the passport, the assisted living waiver, and of course, nursing home Medicaid. But also I'm going to talk a little bit about some of the things that you have to do to qualify. And I'm going to talk about some of the things that can be barriers that you might need to expect. So let's talk through passport. Passport is Medicaid for the home. You can get up to about 40 hours a week in home care, right? This is great for couples. Your family members can actually train to be caregivers and get paid through Medicaid, but it has some limitations in that it's not ideal for single persons. And it's also not easy to provide or to find a home health care provider that will accept it. But it can often be the bridge for some families to make it through an brief illness of a loved one. But it's also more designed to keep families, you know, where they often have a goal of staying, which is home for as long as is possible, as is reasonably safe. So then let's talk about what do I need to be able to get access to passport? There is, of course, a financial test. There's an income and an asset test, and we're going to talk about that here in a second. But there is also a medical test. Now, you basically have to be, in order to be eligible, at a nursing home level of care. And that means you're needing 2 activities of daily living, help with feeding, help with dressing, bathing, toileting, or incontinence, and transferring from bed to chair. So obviously, this is some pretty good public policy here. We want to encourage family caregiving in the home. And so we are saying, loved ones, we will make a deal where we will help support you in keeping the elder at home if you are keeping them out of the community care system. And so that is the rationale and the positives of passport, but that is what the eligibility criteria are. Now, let's talk through the assisted living waiver. Again, we are lucky in Ohio, right? It's not as easily accessible in Kentucky, but there is a limited number of facilities, honestly, that accept the waiver. And those that do accept the waiver will often require some period of private pay in assisted living before they will allow the resident to roll to a Medicaid bed. But there is often a problem with this in that you have to be able to access that Medicaid bed, and that Medicaid AL waiver bed may be taken up by another person that has also waited through that private pay. So while it is great, and it is a great payor source for persons that need that level of care, it also has, some limitations. And finally, we have the traditional nursing home Medicaid, right? That's what everybody thinks about when they're like, oh, Medicaid. Now, one of the things that we talk to families about is that, it's not true that Medicaid accepting facilities are quote unquote the worst facilities. Medicaid accepting facilities, nursing homes can't discriminate against recipients of Medicaid. But what our elder care coordinators are doing are helping families find facilities that meet their loved ones' needs, and then also meets the family's financial needs. Is this a family that has the resources to do that private pay for a period of time in the assisted living facility, right? And then is it a continuing care community where they can roll to the nursing home side and then potentially roll to Medicaid if that is what they need at the time? That's the kind of who's got the beds open that our elder care coordinators are absolute experts and professionals at, because that's a changing rubric that changes day to day, week to week, month to month. And so we are your guides in navigating through finding the facility that's right for you or for your loved one. Now we get to the testing part. I promise there will not be a quiz at the end of this, but Medicaid has both an income test, right? You cannot be receiving too much in income, but also an asset test. Well, so we'll start with the income test first. If the Medicaid applicant's income exceeds about $2,500 a month, what's called a qualified income trust has to be established, right? And so any extra income that you're receiving, if you are the person that is in need of Medicaid, is then placed into that trust and is used to feed back to you for care expenses. Now, obviously, this is a state-run program, and so one of the consequences for having this kind of trust is after the passing of the Medicaid recipient is the state is paid back. And so you'll often find these situations here where I'm talking about who gets first crack at what's money is left after you're gone, and the answer is going to be state of Ohio. So there are different asset requirements for single persons than for a couple, right? Both Ohio and Kentucky require that you have only $2,000 in countable assets. Now, there are some things that can be exempt. And we'll talk a little bit about that. You can retain a single car for medical transportation. You can retain a house with an intent to return home. But most importantly, you can now in Ohio retain qualified plans, individual retirement accounts, 401ks that are in payout status. And that's an important change in the rules that just went through this past summer in Ohio. We thought Ohio was going to treat these as exempt resources, and now we can say, for sure they are exempt. And so what that means is, if you have a person that is under the age of 72 and a half, right? The age where you are required to take your minimum distributions from these types of accounts. What you can do is put them into regular distribution if you get one of those tough chronic diagnoses. And in that way, take advantage of the exemption. Now, here again, we're going to have the concept of Medicaid estate recovery. Right? So you can put those plans into distribution and you can make them exempt assets. But after you're gone, the state of Ohio has said, we are going to come after those. Now, for a couple, this is really important. There are the same exemptions, right? But the community spouse is allowed to keep some assets, all right? And so the community spouse can basically keep up to half of $260,000, all right? I've got it summarized in this slide here. Everyone, Ohio and Kentucky both, right, can keep their IRAs and their 401ks if they're in payout status as exempt assets. But in the spousal situation, you are allowed to keep up to $130,000. Now, notice how I say up to, because it's a cap, okay? If you, at the time that you are applying for Medicaid, have $260,000, great, you can keep your 130. But what if you only have 130,000? Then you can only keep half of that, or $65,000. And that's where you get the concept of what's called the spend down. You have to spend that money down to reach eligibility. And there are certain things that we can talk to you about that are appropriate spend downs for your family to help you get to that level. Now, here is one of the things that I've warned you about: Medicaid estate recovery. After the Medicaid recipient passes, the state will seek to get reimbursed for the care provided. So they may file a claim against the estate in the probate court. They might file a lien on that house. They may go after beneficiaries of the accounts. And as I said, Ohio has said it will go after those individual retirement accounts. So that's an important thing to know. Now you're like, wait, what if I'm the community spouse and the sicker spouse, the institutionalized spouse, passes away? You mean to tell me they're coming after me now? No, it's important to know that in a spousal situation, estate recovery will only take place after the second spouse passes away, okay? And the state can only go after assets that are owned by the Medicaid recipient at the time of their death. And that's where powers like gifting in a financial power of attorney can come into place, right? Because we need to get assets out of the name of the Medicaid recipient, right? In order to try to protect them. So people often ask, hey, well, if I know this is coming, can I give my money away to my kids? And the answer is not without a penalty. So Dennison always gives the example of the government says you don't have to spend down to your last dime, right? Be able to access healthcare, all right? But part of that bargain is we're not going to let you just give your money to all of your family and then ask your neighbors to pay for your care through the form of Medicaid. You can spend that money, but only on yourself. So the state doesn't care how you spend it. You can spend it lavishly. You can, get that difficult diagnosis, hop on a cruise ship, ultra luxury liner, and you can take that cruise and come back to the community and come into the nursing home on that first day back, right? And if you've spent that money on yourself, then you've spent down appropriately. But if you gift, there is a penalty. And so let's talk about that. What Medicaid is looking for is, have you gifted within 5 years of application? It's what we call the 5-year look back. All right. And you're like, well, Eva, how do I know when I'm going to need Medicaid and I'm going to have to apply? And the answer is you don't. So what we're doing is helping families plan for the likelihood that they might need Medicaid either within 5 years or maybe in the long term down the road outside of 5 years. What is the penalty? Now, you'll often hear me in this presentation say, for every $7,000 you give, that means 1 month of no Medicaid. The actual divisor is $7,453, but at this point, I'm so used to using $7,000, I'm just going to go with it, okay? But what will happen is if you gift $7,000, that means 1 month of no Medicaid. And that penalty period starts when you need it, okay? So you're not going to be eligible for Medicaid and you have to privately pay for care. So let's say, you have $400,000, okay? And you get a tough diagnosis in 2022. And so you're like, I'm going to give $100,000 to my kid in 2022. So now you have $300,000. And then you start to need long-term care, right? So in 2023, you spend $100,000 on care. And in 2024, you spend $100,000 on care. And in 2025, you spend $100,000 on care. And so now here you are in 2026, you're broke. Okay, great. It's time to go for Medicaid. Well, what happened in 2022? You gave a gift of $100,000 to your children. So you need Medicaid, but $100,000 divided by about $7,000 is 14, I think, 0.3, right? So that's over a year where you don't have Medicaid paying for your long-term care. And, that is where a lot of families find themselves in a pickle, because you better hope those kids didn't spend that $100,000, right? Because if we can't get it back, we don't have the ability to pay for your care. And so what we work with families through is the concept of planning when we have those kinds of problems, right? What are our options in a crisis? What are our options if you need Medicaid right away, right? We can take your money and we can put it into a pooled Medicaid payback trust. That's a kind of trust, where your money is severed, right? You no longer have it, but it is independently managed and fed back to you for your care needs, right? It can be anything from a cell phone to your weekly hair appointment, right? To a private room, because Medicaid only pays for semi-private rooms. And so what we can do is we can take the money out of your name, we can put it into the pooled trust, we can get you a better quality of life as you need to pay for care, and we can therefore stretch your money longer for your well-being. We can use tools like Medicaid-specific annuities to pay for, let's say, a gift that has already been made. And what we do is we convert your money into an income stream. And that income stream can be used to, for example, pay through a penalty period where we've created a gift, we can't undo it, we're stuck with it, right? And we need to make up what you don't have in income to pay for what additional money you need to pay the nursing home. We can also strategically gift. We can also make a gift that we know on purpose is going to draw a penalty period, and we can save that money for your loved one. But know, hey, we're going to draw a penalty period and we're going to be able to make it through that penalty period with the income stream from the annuity. What kind of planning can we do if you come to us before there's a crisis, right? If you are willing to, we can do things like a Medicaid Asset Protection Trust. What is that? Again, that is a gift that we are doing on purpose. So you have to be able to and willing to sever your relationship with that money, right? You have to be okay with the concept. And so you have to have a loved one that you trust to give that to, that you want to give that to, through this vehicle. And what we're doing is we're taking a bet that we're going to make that gift, and then you're going to be able to make it through the 5-year look back period successfully, so that that gift is safe and you've left that legacy to a loved one. So just some things that are important to know. You've got to watch out for things that look like gifts. And so we want you to be aware of commingling assets. Don't pass money back and forth without keeping receipts. Better yet, treat your elder, your loved one, like a business. Get a credit card, right? And use that credit card to pay for those expenses. So you have this paper trail of how things were paid for. You don't want to be stuck in that time that you're applying for Medicaid, tracking down cajillions of receipts to document any gift over the amount of $500, because that's what JFS is asking us to help you supply to them through the part of the application. Better to have that record always, because otherwise you might draw a penalty. Well, so Eva, you might ask, what kind of things might I be able to pass on to my loved ones without drawing a penalty? And so there is an exemption for the home. You may give the home to a child caregiver. Now, the caveat there is you have to be able to prove that the child kept the parent out of the nursing home for a period of 2 years. So,
Hello?
oh, do we have a question? Oh, okay. If we have a question, certainly feel free to interrupt. But for the 2-year child care exemption, a caregiver exemption, what we're doing is we're proving that the child has lived in the home for a period of 2 years, and also that the elder has met a nursing home level of care, and that but for that child's providing of that care, that our elder would have otherwise needed nursing home level of care. And in that way, you can protect the family home for that child. What are other exemptions? If you have disabled children, you can gift the home and other assets to a disabled child. Who is disabled? A child that is on disability via SSI or SSDI. Okay. And so that is, again, good public policy, because we are trying to maintain quality of life for the disabled child. So congratulations, you've made it to the finish line. And now we have successfully crossed the elder care continuum. What do we need to have in place so that our loved ones do not have to deal with the vagaries of intestate succession? So when you die, if you die without a will, the state of Ohio will determine how your estate is distributed. That's the concept of intestate succession. But what that is really, it follows your family tree, first to the wife, then to the children, et cetera, et cetera, et cetera. Now you may say, well, that sounds fine to me, Eva, but what if there are parts of your family that you would not want to receive a legacy? What if there are things that you would like to prepare for? So wills give you a measure of control over how your assets are distributed after you are gone. They distribute your assets to your beneficiaries in the way that you choose. They can be used to delay distribution to minors, and they can otherwise make it clear what your wishes are and make it easier for the person responsible for the distribution of your assets, your executor. So why, Ava, might we then not want to use a will? Okay. Well, first, you need to know that wills only affect assets that do not have beneficiary forms built into them. What has beneficiary forms built into them? Life insurance policies, IRAs, payable on death accounts, right? So if you take nothing from this part of the presentation, this is your homework assignment, and that's to go and check your beneficiary forms, because these will trump whatever you put in your will. And you've got to make sure that they are consistent and with your own wishes, that they do what you want. So one of the things that I like to try to show families is what's going to happen with your beneficiary forms, right? So let's look at, can I get a volunteer from the group? Anybody want to volunteer? All right, that's fine. So let's say we have,
I can volunteer if you need it.
I'm sorry?
I'll volunteer if no one else will.
Oh, that's fine. All right. So do you have a 401k or a retirement account?
Yes.
Okay. And do you mind my asking who's your beneficiary?
No one.
No one. Okay. Well, that's a really easy illustration. So, okay. So this is Julia speaking, right?
Yes.
Yes. So hi, Julia.
Hi.
All right. Can you see that all?
I can see the whiteboard. Yes.
Okay. Are you seeing my writing on the whiteboard, or are you seeing my writing on the slide? Because I'm seeing the writing on the slide.
I'm not seeing it on anything.
Oh goodness. All right. Well, let's just continue with this. I apologize. I thought I had it working, but here we'll go back to the slideshow, and you can see where I've written Julia's name on the slide. But thank you, Julia. So Julia's homework is to go and to attack her beneficiary forms up front. But let's take me as an example, right? Who is my beneficiary on most of my accounts? My husband, right? Who is the next logical beneficiary on my accounts? My daughter, right? God forbid something should happen to both my spouse and my daughter, but at that point, I haven't designated any backups beyond that, right? What I need to be doing is writing my daughter, comma, per stirpes. And so what that's saying is 40 years down the road, hopefully, or 50 years down the road, hopefully, when I kick the bucket, if there has been some sort of family tragedy where my daughter has predeceased me, and I assume my spouse is going to predecease me because he's male, and actuarially the women are going to live longer, right? But I want to make sure that whatever is in that account is not just going to Eleanor, it's going to Eleanor's descendants, okay? And so that's the important thing to think of. Do your forms do what you want them to do, or do they stop maybe too soon? So let's talk about trusts. We're coming up on the end, and I know I said I thought we would have time for questions, but why would you want a trust? Most people think trusts fund babies, trusts are for the wealthy. Well, no, they're a useful planning tool. Trusts are good for when you have a lot of resources and when you think that you might hit the estate tax. Now, the current federal estate tax exemption is, I think, 12.2 for a single person. There's no Ohio estate tax, and it's 22 million for a couple. So if any of you are on this Zoom and you are concerned about hitting that, do please give us a call, but it will sunset in 2025 down to, so we think somewhere between 5 and 6 million. And so that's going to affect some more families likely. And so you may want to do some planning to try to avoid some estate taxes if you, again, are in the position of having a lot of resources. But where is it also appropriate, right? When you have minor children and you want to provide for how they can spend any money, because some people can be the world's most responsible 25-year-old, and some people can be the most irresponsible 31-year-olds. And so you can have some dead hand control where you are saying, okay, you can get some of the money that I'm leaving you, but you can't get all of it. Trusts are also appropriate when you have blended families and you want to make sure that you're taking into account children's on different sides. Finally, probably one of the most famous Cincinnati examples, trusts are appropriate when you want to keep your affairs private. If you want to see Marge Schott's will, you can go to the probate court website and you can, I believe, still look at it to this day. Marge Schott died in Cincinnati with a will. And so everyone was able to see exactly what she had and how she wanted it distributed. So there it is. Not something that all families are necessarily interested in sharing. So it can be a tool that is also appropriate when you have disabled children or when you yourself are disabled. And we talked about some of the exemptions in terms of Medicaid, but you can make special subtrusts basically for your disabled child, which can be used in conjunction with a stable account to allow them to not just live off of their means tested government benefits, but be able to have additional resources with which to increase their quality of life. Trusts are also appropriate when sometimes you need a little extra muscle. I talked about how, we draft our powers of attorney with the language that we hope induces banks to follow them, induces financial institutions to follow them. But sometimes that is, there's a layer on effect if that agent is also your trustee. And so banks often view trustees sometimes as having more power and authority than the agent. And so we, as elder law attorneys, are trying to help you complete the puzzle. We as elder law attorneys are trying to help you create these documents that fits your family's individual situation, your individual needs, the things that you're afraid of versus the things that you want your loved ones to be able to do for you. And we're having the conversations with you about, okay, what do you need to do to prime yourself for Medicaid? Because you're going to need it down the road, right? Or what supports can we put in place so that you can pass on a legacy if that is a really important goal to you, to your loved ones. And then the elder care coordinators are acting on the care side. They are doing home visits. They're attending care conferences and facilities, maybe when loved ones are far away or they can't be there. And they're helping families navigate things like long-term care insurance issues and billing issues even with the facilities. So it's our team's goal that at the end of your time with us, you will feel as if we have helped you put that puzzle together so that you can feel cared for, so that you can feel like you won't outlive your money, and so that you can feel like your decisions will be respected and followed as you make it through the continuum. Because the alternative is not very pretty. And so the people that plan are the people that are best prepared. So with that, I think I've left myself a little bit of time, but I think I've also run the entire time. But I do welcome any questions if you have them.
Yes.
This is great information. Yeah, if everyone wants to unmute themselves, or if you're not comfortable with speaking, please feel free to add your questions to the chat.
But if you have your stuff in a trust, is it the same as whether you own it when you're for Medicaid?
Oh, I'm sorry, sir. Can you speak up a little louder? I can't hear you.
You made a comment about the healthcare power of attorney and specific laws in Kentucky. If you have a house, since Kentucky and, or in Ohio, since Kentucky and Ohio are close, if you have a healthcare power of attorney in one state and end up being in a hospital in the other state, are there any risks of things not being valid?
Well, so wherever the state you are, right, if you don't have it in effect, it's going to follow the law of the state, right? But better practice is to, and under state law, naturally, it will follow to, if there is not one in place, it's going to go in terms of contacting your loved ones. But of course, we would advise better practice is that you generate a new one for, each state. But in an emergency situation, right, if you are wounded in Kentucky and you're taken to University of Cincinnati Medical Center, they're going to go to your loved ones pursuant to Ohio state law if there is not one in place.
Okay. Thank you.
Mm-hmm. Other questions? Go ahead.
Well, one other question, if there's no other ones, while we're
Sure.
so we made a comment about the ownership, if you have to go into Medicaid, of assets.
Mhm.
If you have things like your house, your car, and other things officially in a trust prior to that, is that the same as owning it and that being your personal asset?
Depends on the type of trust,
Okay.
right? So, revocable trusts don't provide direct Medicaid protection, okay? But if you choose to do irrevocable trusts, that those 5-year protection planning trusts, then yes, because what you're doing is you're severing your relationship to that asset. So the answer is just putting it in the trust doesn't necessarily protect it, right? Or make it invisible, right, to Medicaid, because that the items in your revocable living trust are yours. But there are forms of planning that allow you to make it less likely that Medicaid would seek to recover it, or make it so that it is protected. And that's why you come see people like us, or you plan ahead is the key. You say, okay, am I going to be the person that really wants to try to make these kinds of steps in advance to protect assets for my kids, for my loved ones, right? Or am I trying to use them for myself and my partner's care, perhaps? And those are the kinds of decisions that we make once we look at the whole picture for you. Okay, well,
Any other questions?
I have a question.
Sure.
Could we see a past slide of yours about when you need to make sure that your wills and power of attorneys show your restrictions on when you can, I can't even think of the term. Select somebody or turn over your money or something like that. I don't remember. I apologize.
No, you're fine. You're fine. It's complicated stuff, right? So let me kind of head backwards in the presentation if I can. And maybe we will try to get back to what you.
Yeah, I'm trying to find where I started.
Bear with me for a second.
Well,
It was before the passport.
All right, let's
It was
go.
before the three-headed monster.
Let's go backwards in time. I don't know how I managed, Julie, to draw on the.
There were you had 3 things that you wanted to make sure we did.
That's the healthcare power of attorney,
Yeah.
right? The living will and the financial power of attorney. Right.
Healthcare, living will, and power. Okay.
Yeah, and those, because remember, those are the documents that you need in life. We're not talking about the necessarily after you're gone documents, but this is what allows your loved ones to make healthcare decisions for you when you cannot, what tells your doctor your end of life wishes if you want to be allowed to die naturally, and the financial power of attorney with those robust powers, right? Those robust Medicaid powers, if they make sense for you. I'm not saying willy-nilly give, you know, your spendthrift child the ability to gift your assets out of your name, because maybe you don't want to do that, right? But consult with an attorney about what's best for you and your family, right? And then give the powers that make sense, that give your loved ones the flexibility they need to do that kind of planning for you.
Okay, we have all three of those forms taken care of through an attorney, but now I'm wondering the specifics that you're mentioning, like
the Medicaid powers and the power to gift and all the power, something I didn't even mention, the power to handle your digital assets, right? Can your agent log into your TD Ameritrade account and close out your positions, right? You know, take a look at it, right? I know it's legal language. I know it's dense. I know it's not the most exciting Saturday night in Cincinnati. I hear there's a Blink festivity going on right now, and it is wonderful. I went with my daughter and my mother last night, but like, yeah, take a look at it, right? And then, you know, consider maybe having a consultation, whether that's with us, whether that's with your family lawyer. You know, does it do what you need to do now that you might be moving into this next phase of actually needing to use it for things like Medicaid?
Thank you.
Thank you so much, Eva. I think, do we have time for one more quick question, or do we need to wrap up?
I think I saw somebody light up, but I'm fine to take one more.
Okay. Any other questions?
Had a false start. All right. Well,
I do think the good news for this is that it will be on the website. So people like me that aren't financially oriented can listen to this again and again and again, maybe. And hopefully we've all taken some time to make this our priority. I know I don't, embarrassingly, I don't have any of those documents ready. So for those out there that are like me, let's do this. Thanks so much for your time, Eva. It was a wonderful presentation.
And thank you so much for inviting me. I know I sound like an evangelist, but I mean, half the time I'm just telling families, you know, you can do this, right? You're going to feel so much better when it's done. It's never easy to have conversations about long-term illness, chronic illnesses. It's never easy to have conversations about death.
Right.
It's never easy to confront one's own mortality, but unsurprisingly, it's going to affect us all. And, you know, I like to think, and I tell our clients all the time, knowledge is power, and we will get you through this together. And we will also help you fill out your forms if you get that done. And we will needle you to fill out your forms, because once it's in place, you will have gifted your loved ones the gift of being prepared. So
I just like to say too, Eva, thank you so much. It's very informative, even though I've been through some things. There's some extra points that you made today, and I really appreciate that. I know of people that have used Dennison Keller, and they've been very happy. And so, you know, with services there, and I just want to thank you for coming on personally today.
I'm happy to be here. And like I said, I'm not kidding when I say I feel really, really blessed and honored to be part of this team, because I don't just look at families and say, here are your documents, off you go, right? Really can get into the thick of it and help solve problems together.
Definitely. Thank you again. Have a good day.
Great. Thanks, everybody. Get outside, get to Blink. It's gorgeous.
Beautiful.